Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rabia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rabia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rabia. 1. Whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2. Whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench: whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications that require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3. The decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rabia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena President, Party President, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the Legislative Party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena.